Welcome to Legalized Negligence, where we discuss Florida Statute 768.21, subsection 8. I'm here with my friend Travis, and we've got a special guest today, Marcia Scheppler, who has been on with us before, and she's going to discuss a civil case that is ongoing with where her son was ignored by a hospital and died. Forgive me, have been sick with the flu for a week, and I think I'm getting better, but I'm going to try not to do a whole lot of talking and just let Marcia tell this story. And if Travis has some questions, he can ask. Marcia, let's be clear very upfront. If I'm understanding this correctly, if you did not have a friend who was an attorney who was willing to take this case pro bono, you would not have gotten to where you are today. Is that correct?
That's correct.
Okay.
That's correct. I did set a contract, it is, if we collect damages, she's still going to get, the court costs and things like that. So
Right.
It's not essentially pro bono, but she's willing to fight it till its bitter end, in spite of the fact that we went in with literally no hope of being able to pursue, the much of anything. We've tried several different avenues. There was the filing under 393, filing under 415, and these are both statutes that are written to supposedly to protect people with intellectual and developmental disabilities from, medical negligence and neglect, among other things. We did the EMTALA suit, but that was also dismissed in court because of the little, missing, item of not being able to sue the hospital itself. You can only sue like the actors and administrators who are on site at the time of the occurrence, which of course, like with Joseph, it happens in the middle of the night. How many times do you find an administrator in the emergency room, at night? So
I think the important thing here is that your attorney friend was willing to take a huge gamble that she wasn't going to see a dollar out of this.
Right.
And she knew what the risks were, that she stood very little chance of getting anywhere with this. So it's different than everybody else, that we don't all have friends who are an attorney who is willing to take that risk,
But it's not even just I did not know her before this happened to Joseph. So what happened is of course, at the second hospital who did treat Joseph, the charge nurse and I became friends. And the charge nurse has a son who is like a JoJo, severe developmental disabilities. It just so happens that her daughter also is a medical malpractice attorney. So with what happened with Joseph, of course I told them in the hospital, and they heard us, talk about it at bedside and things like that. And I actually met Cassidy at Joseph's wake. And of course, I didn't talk to her about it right then. But, I heard afterwards from Ramona that what Cassidy does for a living. And then she brought on her partner, Matt, and they, both of them have been absolutely wonderful. They have told me before, when I was worried about them, giving up, because, they're putting all this money out, time and effort, money without any promise of return. And they're like, no, we are in this. And I believe that in spite of what happened to Joseph, God puts people in your path. And that there are two ways to change a law. One is through legislation, and the other way is through case law in court. So, I've been making efforts to change legislation, but I'm not going to give up on the case law also. And of course, there are other extenuating factors that are special to Joseph, being in the fact that he was a person with severe developmental disabilities that I had pursued and became his guardian advocate. So he was adjudicated in Florida by a Florida judge on his 18th birthday to be unable to marry, unable to enter into contracts, those things that, he was unable to, get a driver's license, to vote, anything that makes you an adult. Joseph was unable to do, was legally unable to do. And those things that he could do, like decide who he wants to go to the movies with, was subject to my approval. So, interestingly enough, one of the legislators that Sabrina and I visited last week said to me, he said, Marcy, because what? Okay, let me back up. I said to him, do you realize how crazy it is that as Joseph's mother and guardian advocate, I could have been held criminally negligent if I had not taken him to the hospital to get him medical care and he had died. I said, but then I turn around and the next day they're saying, well, now you're not really his mother or anybody important, that you should be able to pursue a lawsuit for this.
That's a very important point. That is an extremely important point.
Yes.
Yeah. So for people who may see this video and haven't, aren't real familiar with the law and stuff, subsection 8 of 768.21 strictly, it specifically forbids recovery of non-economic damages. A lot of people say that it prevents you from getting into court, but it doesn't do that. It prevents you from recovering damages. And because you can't recover damages, you can't find an attorney to take on the case. Well, in your situation, you happen to have found an attorney willing to do that. And that's why I think this is so important to get this information out there, because if your attorney wins this case or even makes some progress in this case by getting it out in the public, that's a huge step forward for what we're trying to do. So if you don't mind, kind of take it from when the attorney filed the initial filed the initial complaint. Take us from there and tell us, then go to where you are with it today.
Okay. So the initial filing, I believe, was under 393. And we went all the way up to the appellate court. There's 393. It has a clause in it that would protect people who are under guardian advocacy and are on the med waiver program, which most people who have intellectual and developmental disabilities in Florida are on the med waiver program brought by CMS, to be able to file medical negligence, but it's not worded right. So we took it all the way up to the appellate court after it got dismissed, and the appellate court dismissed it, said they had to reword the complaint. What costs a lot of money to go to the appellate court. So they went ahead and rewrote it under 766, which is medical negligence. And for the EMTALA, which I can't remember which one it is, honestly, the EMTALA claim got dismissed because of what I said before. I think the judge was trying to take away something and give something, a swap, so to speak. And he allowed the medical negligence under 766 to continue. And there are, like I said, extenuating factors in that. And my attorney even said, when he was arguing, this is Matt, the co-partner, he said, we realize we are treading into unknown space here. But, does the judge really want to say that a person who has severe disabilities and who is 10 feet outside the hospital, is not worthy of being treated? The Cleveland Clinic's defense was saying that, he was refusing to go in, but that's saying, like, would you put your 2-year-old in charge of their own medical decisions? And of course, I was right there with the guardianship advocacy paperwork. I have the right of medical, attorney. And then they were saying that they went back and they said, well, then they should have filed the EMTALA one. Of course, they already got that one dismissed. So they were trying everything. And let me just put this out there too. COVID severely put us behind in the thing, because this happened to Joseph about 6 months before the first COVID case. So after that, then there was a 2-year delay. And then Cleveland Clinic has done everything to stall. They've filed like 4 motions to dismiss. They have fought tooth and nail about, getting a deposition from the main actor, the charge nurse, who denied emergent services to JoJo, and then everything to block us. So when the judge said that he felt that this was a medical negligence case and that we had proven the case enough for it to go forward, of course, it was sorry, it was like a miracle, and my attorneys are, fairly certain that we will be able to collect damages for this. And there's a couple of reasons why, but and one of them, when I was talking about the legislator I talked to, after I told him, put it out there that I could be charged with criminal negligence, for not taking care of Joseph, he said to me, he said, Marcy, he said, if somebody has a guardianship, legally their age freezes at that point because they are never, if they're incapacitated, they are never truly an adult. Their legal age is 8. JoJo's legal age would always be 18.
Wow. There's a new one. I didn't know that they viewed it that way.
But does that supersede the age definition in 768 or 766?
I believe it might. I actually spend a lot of time today looking up the 393 statute, the probate statutes, and everything to see, how they're worded. Plus, other attorney sites for guardianship and things like that. When I looked at Joseph's, advocacy or, guardianship paperwork, literally every right that makes you an adult at 18 was taken away from Joseph because he was mentally incapable. And it says on there that he had developmental disabilities and mental retardation. He was legally not an adult. So I think that is one of the ways where we may be going. Which is, and the other thing is that the guardianship advocate paperwork was a legal and binding contract between myself, Joseph, and the state. And there is in the Constitution a protection for contracts that cannot be overturned by legislative act. I'll have to send that to you. But that's Sabrina sent that to me. I'm not sure where she got that, but I mentioned that to my attorney too, and he was like, "Wow, I have to look up, that one also." But it is a new set of rules because I don't think that there is a case that's quite like this. If I've not been able to find one where the person has severe developmental disabilities, and this is a medical net that he had his capacity taken away from him, and the whole shebang. And I'm not sure what judge would want to put his name on a ruling that said, I'm not going to protect somebody who is this vulnerable. Mm-hmm. That's another thing we have going for us. But yes, we are pursuing in court and we're going forward. I mean, Cleveland Clinic does have the right to appeal, and you know that they will. I don't see him overturning his own ruling. He has thought long and hard about this. He actually had, the filings for a while, and he asked my attorneys to amend it in a certain way, and then he pushed that through. So I think he has thought long and hard about this, and the Cleveland Clinic's, their arguments against, or for dismissal of the medical negligence were not very solid at all.
Yeah, that text that you sent to us a few days ago saying that you had a victory. Tell us what that victory was.
That Cleveland Clinic's request to dismiss the medical negligence suit was denied, and that the medical negligence was upheld by the court and is allowed to proceed. So after the appeal, they get 15 days to file an appeal, and then if that is not, he doesn't overturn his own ruling, then we can get our full discovery and start building up what damages should be in place.
Exactly. Yeah.
Mm-hmm.
I think this is so huge. It really is.
It's huge. It's not just like for JoJo's. I mean, if you really think about it, because I was thinking about it earlier today, let's say we have a senior who is incapacitated.
Yeah.
Yeah. And they're, they have a medical proxy and things like that. It could open the door for things like that.
But see, if they freeze the age at the date that the proxy or guardianship takes effect,
mhm,
are they beyond the age then?
yeah. Technically, JoJo was never legally an adult.
Right, but you had mentioned if an adult becomes, a ward of someone,
Mhm.
they would be an adult in the eyes of 768.21. So would that be of any benefit then?
Oh, I think it would be because, really these laws are all supposed to work in coordination with each other. You can't say he's an adult here and not an adult here. You know what I mean?
No,
So
I understand.
you
I
have
just
to-
think
yeah,
maybe the way the law is written might need to be addressed.
oh yeah, of course it does. And there's so many laws that I wish I didn't know this much about these laws because it's really scary. Just the little omissions that can happen, they can really ruin a law that was supposed to be well-meaning. But I don't think legislators, really thought about, you know, different scenarios. It can't to me because then we wouldn't have the 768, wrongful death act in the first place.
Unintended consequences, and our
Mhm.
leadership they're not forward thinkers.
Right.
They don't extrapolate
Mhm.
what they're putting down to law, into multiple enumerations of what it could become.
Right. It must have been a very reactionary, type of, statute to like they were like, oh, let's just do this, and without really any forethought. Because
Yeah,
look at all the different, yeah, I mean,
and just on its face, it failed because it was enacted in 1990 to bring down the cost of malpractice premiums, and here we are 34 years later, and they're claiming that those premiums haven't come down. So, like a letter that I sent to Senator Book today, I just laid that out to her, and I
mhm,
said, if that was the purpose of the statute, then it completely and utterly failed to do what
right.
was enacted. So maybe it's time to go back and correct this error.
Well, she does believe that too,
Oh, I
and
know she does.
yeah,
Yeah.
that,
Yeah.
and
It was
that
a,
was a point that was made repeatedly in every single one of the meetings that Sabrina and I had last week.
yeah, it was a friendly letter. It was in
Oh yeah.
support of her. I
Mhm.
understand. She and Lopez have the only bills that do exactly what we're asking them to do. Just strike subsection 8 and put
Mhm.
things back to where everything is on an equal footing. All the other bills have all these caveats in them. But
Well, I mean, but to be fair, the Senate Bill 248 does strike, subsection 8. It puts now they're saying they're going to put the caps on it. Supposedly, from what I understand, the stipulation about ACA or DOH is going to be eliminated, but they're not going to get it to go through unless they add caps. Of course, then again, we've been saying for years, it's not about the money. If it eliminates the category, it gives some avenue for people to pursue the injustice. It may not be perfect, but it does give some avenue. So I have to say, that's a start. I'm, I think that the stomping around the capitals, yelling "kill the bill" and harass the legislators is not the right way to go, and will actually probably prevent any bill from being heard in any reasonable amount of time.
now, Travis, you just heard what Marcia said, and you have heard me say that for a very long time. The point she made, the people, us who have had loved ones die from malpractice, we have got to decide what it's about. We always say it's not about the money, but then we want subsection 8 repealed so that we can sue for those kinds of damages. So, we've got to get it clear in our heads exactly what we're asking for, which it
Yeah.
leads back to that question I posted in the group a couple of days ago. And I said, well, what would you do if, and it was totally misunderstood, but you got it, Travis. Anyway, um, so now we're waiting for the other side to appeal the judge's
Yes.
decision on that, and they have 5 days to appeal that. And
Mhm.
if their appeal is not successful, then you get to move forward with your discovery.
Yeah. Yes.
Fantastic. That's
Yep.
fantastic.
And it that way, with the discovery and even without, the medical negligence would be, reported in as a case that happened, it was allowed to go through. I don't know how much the damages would be. It's not enough to bring JoJo back, but if it opens up the door for, consideration of future cases, then that's what I said I was want to do. I wanted to save the JoJos. That's what I'm doing.
Yeah. I'd like to make a comment about, you used the term earlier, case law. I know that term is used in the legal world all the time, and there really is no such thing as case law. Law can only be made by the legislature, but we have accepted that they'll call something case law, when in fact what it really is precedent set and accepted by a court.
Right.
So if your judge issues a ruling in a particular way and other courts begin to follow what that judge does, that's what they'll call case law. But if it's true law, it was written by the legislature, passed, and was signed by the governor into law. So
that's true.
Yes,
that's true.
I don't want people to be confused by that term.
But it will give an avenue.
Absolutely.
Because, yes. Yeah. And so I'm very thankful to the attorneys. They've been wonderful. And just they've given their all to this with, like I said before, no promise of any return.
Well, will you promise to come back as things move along and keep us updated? I'm just on the edge of my seat about this. I think this is so wonderful.
Yes. So do I. In court, my attorney at the end, end of this last hearing, he said, "Are you going to write a short order or a long order?" He has to write the long order for it really to become a precedent. So he's doing a short order this time. I'm sure he's waiting for the appeal. Hopefully we'll get a long order, and then people can refer back to the court case and say, "Well, look what happened between, Thompson versus Cleveland Clinic."
Yeah. And if your attorneys ever feel like, doing a podcast with us to explain a little bit more in depth, that would be great. They're always welcome to do that, but I know they're very busy. And, but if they decide that, hey, that would be a good idea for us to explain this, maybe other attorneys will listen to it and hear what we're doing. And that way you get the word spread across the state to other attorneys to maybe pursue a similar situation.
And, I hope they would be. I actually thought about sending something out to them, but it's kind of like a holiday day.
Right.
So I was already texting them like 1,000 times earlier when I was going through the statutes, trying to think of what else we could bring up to help support our case. So, yeah.
Travis, do you have any other thoughts on this that you'd like to ask?
Well, I'm thinking that what Sabrina had mentioned about the contract law that's constitutional, is that you can't have a law that inhibits a contract. So that'd be what, like based on constitutional. I don't know if that would apply in this case, unless Florida had a similar statute that mimicked the Constitution.
I'm trying to look it up. If you find it, let me know. But it's, it is something. It says no state legislation can, overturn this contract. I'll have to send it to you. I don't know it verbatim right now.
Tell me which contract you think that the law has violated. I'd be interested to look it up that myself.
The contract that I filed, as to be a guardian advocate for JoJo. And because that's kind of like, I'm promising to take care of Joseph, to act on his behalf, to, always look over him, not just as a natural mother, but, as his guardian.
So then if we can answer the question that a guardianship is viewed as a legal contract, then we would have our answer.
Right.
Okay.
Right.
Right, but that would be between you and the state then. So 1983.
Yeah, I'll be interested in looking that up.
I'm going to be doing a lot of research, and like I have been from the get-go. As soon as I put together that Joseph, was not responsible for himself way back, before we actually filed, and that's the reason why 768 should not apply to him in the first place, because he was adjudicated by a Florida judge to be unable to do anything that 768 requires except for age out of being protected, which as a vulnerable adult, there are statutes in place that say these people must be protected. So what happened?
Article 1, Section 10, Clause 1. No state shall enter into a treaty, alliance, confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender in payment of debts, pass a bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility.
So you
Right.
would have to show that it impaired your obligation to that contract.
Right. There's also freedom of contract, a basic right reserved to the people by the Constitution, Article 1 and 10, that states that the state cannot violate even under sanction of a direct legislative act.
But you have to put those into context. And the one Marcia just read is my right to contract with my neighbor. The state can't violate that right, and they call that an arm's length contract. I can contract with my neighbor to do something, and the state has no say in that. And the one that Travis is talking about is something a little different than that. So we got to put each one into context to see if it fit.
Yeah, this one refers to the obligation to contract, or impairing the obligation to contract. So somehow we're gonna put this one together, because anything that you guys think of, could help move this case along, and but I think it really says something that the state already said, that Joseph can't do any of those things that is required by 768, aside from just not being protected. And then you have to think about it. That means that 100% of people who are born with severe developmental disabilities will never be able to access a court and will always grow out of being protected. 100%. How did that happen?
Yeah, well, again, like I've always said, the unintended consequences of poorly conceived legislation. The legislators can't think of it all when they write a bill, and it's only after the bill gets put into law that the people start bringing their objections through lawsuits back to the state to say, hey, well, what about this and what about that? And that's why they're always going back and adjusting these laws, because people are going to point out to them how you didn't think this through very well, did you?
Right. Yeah. What is surprising to me is that, maybe it's a good thing, that I don't know of another case like this.
Yeah.
And so, but how could they not think about people with developmental disabilities who could? I don't get it. I don't get it. But anyway, I'm trying to do something about it. My attorneys are trying to do something about it. Case law, case precedent, whatever you want to talk about, legislation. I hope something can happen, hopefully on both fronts.
Oh, believe me, I'm right there with you. I'm 100% behind you on this, and I want to do whatever I can to help move that forward. Travis, you read my letter to Senator Book. Can you think of anything in there that might be able to help Marcia? I've been sitting here trying to run over the talking points in the letter.
I'd have to look at it again, to be quite honest. Not off the top of my head. What I was thinking about just now is, Marcia, are there any support groups, organizations, associations that you could let know the good news? And
oh yeah, and I've sent some texts out and things like that. And I have prior to this whole legislative season starting, is trying to get special interest groups who serve people with developmental disabilities to be on board with SB 248 or House Bill 129 in order to help pass these laws. What I have run into is that there's no direct link, they say, and because it's so rare, apparently, it's been very hard to get the big organizations to sign on. However, I do have a lot of like, Facebook organizations, smaller organizations that are, run throughout Florida, who are very much supportive of, my intentions of getting the bills passed and have been supportive of me. In the very first legislation delegation that I spoke at, there were members of, there were members who stood up with me. So, I hope that I can. I wish that there was something in the, I think it would be helpful if there was something that said, to protect people with developmental disabilities somewhere, someplace, and then the big, organizations would sign on to. But you do what you can. If enough of the smaller people, speak up in the right way, respectfully, then hopefully we'll be able to protect the JoJos in Florida along with everybody else.
Yeah.
I'm working on it.
All right. Well, keep us updated. I am like, to me, like this is the biggest thing that's happened lately.
Right?
That the judge is saying, we're going to let this thing move forward and see where it goes. I think that's great.
It's a miracle.
So,
So yeah.
all right.
Well, thanks for putting me on again. I'm gonna go back and watch my Bills hopefully stomp them, and win, get to the bowl.
I'm not a sports guy, so I wouldn't know a Buffalo Bill from a Tom Hanks. Yeah, I have no idea what any of that is. So enjoy your evening. I hope your team wins.
I hope you feel.
Yeah, thank you. I do too.